Okay, and we are on air. I see a lot of people connected, which makes me really, really happy. So, my friends, hi everyone, welcome you all to another webinar of this International IP SME Helpdesks, this service of the European Commission that provide free first confidential line assistance on intellectual property related issues addressed to European SMEs that are operating in Latin America, China, Southeast Asia, or India, or are willing to do so. Be very welcome. For those of you who don't know us, may be surprised by the offer we're going to provide to you. And for those of you who do know us, will be amazed that we still do that absolutely for free. But let me introduce this for those of you who do not know us. And what we do is absolutely for free and for the good of these SMEs, which can benefit from our trainings, our materials like country guides and infographics, videos, our cost tool and IP diagnosis tools, and much more. And of course, our helpline, which will provide you with an answer within 3 working days and with no limits for queries per user, which is absolutely amazing. You'd agree with me. Now, this training is, you can find all the information up there, so do not hesitate to visit us for further information. If you want to know more about it, just go and ask. Now, this online training is part of one of our pillars, which are trainings, of course, and you may find it too basic, but don't you worry, because you can find all our upcoming and past webinars in our website, and of course, we are open to suggestions, okay? And also, it is supposed to be business oriented and jargon free. So if you see that we are getting you puzzled, just let us know, okay? Now, let's start. Today, we're going to know more about the, no, sorry, yeah. We're going to know more about the 10 basic IP tips that I consider will serve you to succeed abroad. Of course, there are more, and the newcomers, and this training is for them, will have a reference, and the more advanced users won't deny that they are true, okay? My name is César Fernández from the Latin America Helpdesk, and I'll be your main speaker today and also the moderator. But I will be very well assisted by my colleagues Hana Onderková from the India Helpdesk, Mathias Zubimendi from the China Helpdesk, and of course, Benoît Tardy from the Southeast Asian Helpdesk. You have them all right next to me. Now, before we start, I just want to introduce some technical aspect because this is a new platform for most of you and you may not be familiar with it. So I'd like you to know it a little bit in detail. We're here to be squeezed by you all, note down. So do not hesitate to let us know your doubts and impression by using the question box in the right side bar. Questions about practicalities as well as IP-related questions will be held on until the end of the presentation when the Q&A session will take place. In this regard, please bear in mind, then you can ask a question yourself, for which you only have to request so. You'll be called to stage and you'll be able to ask the question again during the Q&A session. Please do not forget to activate your micro by then. You're also invited to interact with each other, so do not hesitate to write anything you feel like in the chat. And now that we're clear about this, I'd like you to take just a single minute to do the test of the link that it's going to be just right now pop up, so we can really measure the knowledge you have on IP. You can find it right now, has been, that's it. You have it on the chat. So just click on it, visit it, and see how it works. Now, Catherine Fidelis says that sound is not working properly, although we did a test and all the people who answered said that it was right. So please confirm. In the meantime, we have a minute. So please let me know if you know anything that you're supposed to know about intellectual property. Now, some of the main points that you should learn today are included, of course, but I want to be really sure whether our expectations are realistic or not. So please go ahead. Okay, the time passed by, and I'm very grateful for all the answers provided. It seems that we're having some problems with some of the audience because they say that the sound is not working properly, while some of you say the contrary. So, uh, our IT people would like to guide you on this, but this is a problem that we can really handle ourselves because this is a browser-based service, and for the most of us do really work properly. So, my apologize if it doesn't. Anyway, you're going to receive this recorded version of this webinar afterwards automatically. So I'm really sorry about this because you're not gonna able to hear that live, but you're gonna have the chance to do that afterwards. And anyway, you have the helpline service. Should you have any questions, you can address us. And again, I will apologize for this. But now I have to dive into what we are here all for. So I'm gonna hit the main theme: IP tips to succeed abroad. Now, the first tip I'll provide you is that you have to seek professional support. Well, first, because you simply cannot do everything, okay? It's good you to train yourself or train your staff, but you should rely on experts like the helpdesks, for instance, and ultimately on IP lawyers with experience in the geographical area, in the sector, and your type of organization, because small, medium-sized enterprise tend to work differently. These professionals will help you in designing not only your IP strategy, both from scratch or in the case you have a really bad one and you're facing real problems, but only but also will be able to identify your needs, and that would be translated into a more realistic strategy, which something is not a easy task because you're absolutely conditioned by your own vision. The second reason for doing this is because the IP scenario that you will find in Myanmar, Thailand, Brazil, China, or Mexico may vary so much that it is almost impossible that you can overcome this language or cultural or regulatory barriers on your own. You must rely on someone who knows how to deal with that and has some experience in this. And in my perspective, this outsourcing is even inevitable in certain cases, and our experts can confirm that. For example, in China, it is mandatory for those companies that are not registered there. Companies who have an address in China can use their internal department, however, but the ones that are foreigners, like maybe you, will need to hire a local IP attorney anyway. And this may be also the case for those who are trying to go to Latin America. If you don't have a local domicile, you need to appoint a local representative. And in order to register and in order to defend your rights to enforce them, it is more than needed an IP attorney that has experience over over there. So the smart strategy would be to find the right balance between this outsourcing, rely on these IP experts, and internal management, training yourself. This is what this training is for, right? Now, speaking of strategy, which would be the second tip to bear in mind, is that you have to prepare it and to develop it beforehand very carefully. It is really advisable to avoid reactive actions, okay? Like when you have to already being copied or when you receive the cease and desist letter, which is more common than you can imagine. Also, unless you are Apple, you have to avoid registering IP rights like a patent because yes, because you must trust that you're going to find that some utility afterwards. It doesn't work, okay? Strong rights take a lot of money, time, human resources. It's not a game, in short. So you'd better prepare it carefully, including what IP rights are essential to your business, when and how to register, exploitation strategies, knowing the right business model, which is more important than you can imagine, and of course, the countries and activities of interest to you, even in the long term. We are talking about lots of countries in here. Latin America is more than 20 countries. Southeast Asia is more than 10. And even regarding China, you must consider mainland China, Hong Kong, Macau, and Taiwan. And there is no unique and global protection strategy. There are several differences, and some of them will be addressed later, of course. Now, this will be the second tip I'd give you. What about the third one? It is pretty basic, and as sound as it is, as basic as it sounds, it is as useful as it sounds too. You have to collect all documents concerning the creation and use of your IP rights, because having a well organized place where you can find all the original sketches, the licenses, and the certificates, that would be perfect. So you can, for instance, prove easily the authorship and that you are entitled to do what you are doing. And this is particularly useful in case of a legal dispute, of course, because most of them are really hard to find or are absolutely needed for that. And what is it good for too? Well, this would be good because it would is knowing what you can do with the IP rights at hand, which is a source of conflict in big or chaotic companies or in those with high staff turnover. If some of the personnel just downloaded a picture and you don't know where did he or she take that from, you don't know exactly what to do. But if you have all organized and you have access to the license, that would be more than perfect. And it does not affect only the pictures you get from an online stock footage platform like iStock or Shutterstock that you use in social media that I mentioned, but also the reports that were shared by a partner for a project, or the sketches or drawing of the logo or mascot that finally became a trademark. You name it. There are a lot of them. And you may also consider translating some important documents into the local language whenever it is necessary. For example, some IP offices in Southeast Asia do not accept documents in English like in Thailand or in Cambodia. So I think also in the legalization of those documents to save time and have it all together in this database if you want to save time and money in case of conflict. Okay? Now, the fourth one would be start protecting your IP rights before entering the market. This is so basic, and yet it has been so much oversaw by people and just try to go there and try their luck savagely, and it doesn't work. The first reason for this is because IP rights are territorial. Hence, you must register everywhere you aim to operate to be safe. And what will happen if you just go there widely, so to say? Well, your product could be seized by the customs for IP infringement of a local registered trademark, which isn't good, right? Or you may find too late that your company's name was already registered by a local company, of course, in good faith. They are bad faith registrations. And how do you get to know that? Because you will be facing legal actions for infringement. So now IP rights are territorial, you know that, we all know that, or we're supposed to know that. But why can't I register proving that I operate that under that trademark, specifically in many other countries with great success? Well, this is because of the first to file principle, which is very strong in China and is generally followed in Latin America and Southeast Asia, with some exceptions, of course. What will be the solution for this? Well, in case you face these really bad scenarios where you're already seeing that your brand is already taken, for instance, you either create a new branding, which is really expensive and does not prevent you from checking its availability anyway, or you have to discard the country, which is really a big fail. And we'd like to avoid this kind of fails, right? So do that in advance in order to avoid this kind of undesirable surprises. Now, this wouldn't happen, of course, with a good planning by good IP experts. And the first point is going to be the most important one because it does really affect any of the other ones. And conducting preliminary searches at a global level is part of a careful design protection strategy. Okay, so all the destination countries, in this case, have a publicly available database for carrying out searches. However, the percentage of available data is very different from one country to another, and the information is not always displayed in your local language. So, for example, it is very easy to search for trademarks in the database of the Chinese, the Mexican, or the Singaporean IP offices, but it is almost impossible, not to say impossible at all, to do an online search for a trademark in Myanmar. Of course, you can always check the international regional databases like PatentScope, TMView, or DesignView, but some countries do not submit their information, so they are not as comprehensive as we'd like to. And of course, you can also contact the national intellectual property offices, as most of them perform non binding, remember this, prior searches. But you either have to pay for this, or in some cases, they are absolutely for free. But again, if you want it to be as comprehensive as it should, you have to rely on IP experts. Anyway, if you want to know more about where to look for this kind of prior rights in order to have a very good and strong right, just contact us and we're gonna let you know. Now, we're coming on the Ecuador of this, and the sixth point would be taking care of your first filing. Why? It's simple because it is your gateway to international and even national protection. Now we gotta split this into two phases. The first one would be before registration, and the other one would be after registration. Okay. And now, speaking about before registration, you have to take care very carefully and have a strategic and prior rights and state of the art analysis. Now, the state of the art means anything that's been made public, maybe public anytime in the world by any means, which means a lot. And when it comes to trademarks, it means that you have to have a very careful analysis when it comes to choosing the right name of your company if you're starting from scratch of a product. And when doing so, you got to think globally. And this is really, really important because many people just tend to think locally. Okay. And now you not only have to think globally, but you have to check whether this chosen sign is available and it can be easily reproduced and it is distinctive in any of your destination markets, not only in the short and medium term, but at least in them, but also in the long term. Okay. And don't do like BlaBlaCar did, that it was operating for years with a non-distinctive, hard to pronounce name until 2013, when they rebranded the company to something more international, but it was Covoiturage until then. And you would agree that those non-French speaking countries would have had a problem in trying to call it. Now, you also have to take care of many other aspects, like, for instance, making sure that it is not an offensive or contrary to morality or ridicule in the local language term, which it happens to be very usual regarding China. And regarding this country specifically, an adaptation is very, very recommendable, if not key. For instance, trademarks can be modified into Chinese characters in order to make them easier to be remembered by these Chinese consumers. Also, the logos and the international names should be registered as well, but an adapted version is advisable as said. And of course, the phonetical translations should be done carefully, as some characters will be used since some of them might contain negative meanings, and it's something that I would like to avoid. Now, when it comes to patterns and designs, performing this careful analysis and the best way to take care of this first filing is the best way to have a strong right. And if you perform a serious search of prior rights and see what the state of the art is, you will have a real picture of whether this invention of yours or this pattern or this design is really new, meaning that it would meet the novelty requirement or not. And you have to be rigorous about this and have to be honest to yourself. If you find something that is similar and therefore would harm your pattern or your designs applications novelty, don't do that, because otherwise you're going to have not a strong right, but um, um, a very weak one. And when you're trying to license that afterwards, you're going to have some liability problems, because somewhere someone is going to find that this is not new. They're going to go to the courts and they're going to shut it down, and you're going to have to pay a lot of money. You're going to lose your exclusiveness, and the partners of yours are going to be let down, and you don't want to do that, right? So you have to be very rigorous when conducting the searches, and it is almost impossible because if you have to take into account anything that's been published in by any means in the world, you have to take into account all the literature, including all languages. And when it comes to Chinese literature, not even the best IA guided programs can help you figuring that out. So you'd better rely on professional support trying to avoid this. Okay. Now, this would be before registering, but once you register your very left first filing, what do you have to do? Why I recommend you to do? Well, when it comes to trademarks, um, this is very good if you do that because your own rights would allow you subsequent successful registration, mostly on denominative and predominantly naming signs. Why do I say this? Because trademarks normally can be renewed by 10-year periods indefinitely, meaning that if you manage to register your trademark, as long as you pay the fees and it was well did at the first instance, you'd have it forever. So you can build your reputation based on this strong right year after year, and as long as you became more well known, your trademark will have a bigger value. And you can have some modification on this because you protected the very same name of it. So if you do that rightly, it has a big impact. Now, when it comes to patents and designs, um, once they are registered, you have to please bear in mind that you have to pay the fees sometimes on an annual basis, sometimes on a 5-period annual basis. And this is very common that people tend to forget about it and then they become canceled, and it is part of the public domain. Of course, there are some periods where plus a surcharge, you can recover that, but I'd recommend you to pay attention to this in order to avoid this. And of course, if you do this, please take very well attention about um, these documents if you put that in the database we mentioned, right? Because that would help you to prove the authorship and date of reference, which is very useful in case of copyright. Okay. And the after registration benefit for the all of them, not only patents but also designs, trademarks, and copyright, would be that it would open many gadgets for you to say. So you have that priority right in case of the Paris Convention, 12 months for patents and 6 months for patents in case for designs in Latin America at least, and for you have access to the PCT, which opens a window of 30 to 31 months to think what to do with it, keeping the novelty. And this is just because you did that well in the first instance and you have the first filing well done. So keep that in mind when you are trying to make the approaching IP intellectual property for the first time. Which takes us to the seventh tip, which is monitor markets and behavior and competitors' behaviors, because it will be very useful to identify um, not only infringements but also opportunities. What do I mean with opportunities? Well, that may serve you to know what technologies will come and if your products and services can find a niche or not. And it would also be useful to see what technologies are needed to compete, because interoperability is really needed nowadays. And in general, it is good to find if someone is using your creations or is copying it without your authorization. And of course, you can just start some legal actions, but you can also find an amicable solution and find a new partner all of a sudden. Just think about it. If you want to know more about these strategies, just ask us and we'll let you know. Now, of course, it is really hard to do that if you're trying to do it yourself. So my advice would be to activate a worldwide surveillance system. Normally, the IP lawyer that registers your rights for you is going to be able to provide this kind of services because this is absolutely needed. Why? Because registration does not provide automatic enforcement. You must defend your rights, for which you must remember that only registration provides exclusive right, and there is no IP right infringement if there is no IP right registered beforehand. Okay, and of course, it is really important that You must do that fast, and you must collect the evidences to stop it as soon as possible. But before making any move, you'd better contact your IP lawyer. And we've mentioned a lot of them during this very short and straightforward webinar, but you also have to get familiar with local particularities. You can see some of them. You can see that, for instance, there's a patent and design grace period that we mentioned. In Latin America, you also have the ex officio relative grounds examinations, meaning that all the registration proceedings when it comes to trademarks tend to be very a little bit slower compared to the European timing. And it is almost universal that there is no unregistered design protection, unlike in Europe. Of course, you also have unique requirements for patents in case of India or currency fluctuation. But in this time, I'd like to seek my colleague's support to elaborate this a little bit. And Benoit, you may start saying us a little bit about this. What are the most remarkable differences and local particularities that you'd like our audience to keep in mind when going to Southeast Asia?
Okay, thank you, César. I would say that there's no unique or global protection, as you said, throughout the Southeast Asia region for patent, trademarks, and design. So, in fact, you have a level of IP protection which is available in the enforcement procedures, and these are varying from one country to the other one. So, in fact, you have to check one country by the other. The second point would be like on each of the 10 countries of Southeast Asia, you have very own specificities. So, for example, no copyright registration system available for Brunei and Singapore, no utility model protection in Brunei and Singapore also. And for the PCT, the Patent Cooperation Treaty for patents, all countries for ACA are members except Myanmar, and the Berne Convention, which deals with the copyright. You would see that they're only missing Cambodia and Myanmar. Well, actually, Cambodia, they just passed a new law in 2020. So it's evolving very quickly, and one should be aware in time before planning to go in one of these countries. I could also provide some more examples of the newest developments. I don't know if I have a bit more time, César. Okay. For example, there was recently a new omnibus law dealing with labor and many other topics among the IP, and it was passed in November 2020 for Indonesia, and it was intending to support foreign investment. So there were some amendments in the patent and the trademark law. Considering Myanmar, it's one of the biggest focus currently in Southeast Asia, because during the year 2019, there were several laws passed nationally, and for trademarks and design in January 2019, in March it was the patents, and May copyright law. So in fact, in Myanmar, it's the biggest revolution because there's a whole new system coming, and the IP office is being built in, and official fees are being set, and there will be like a completely new system soon. And I think for me, the last element to add would be like we are very looking forward to see the developments of the RCEP and EVFTA, which are two major treaties which were signed from a specific region, including Asia, for the RCEP, and EVFTA would be a super treaty between Vietnam and the European Union. So we hope that it will also help to improve all IP systems in the 10 countries of ACA. Now I leave the
Okay,
floor to you
thank
again.
you very much, Benoit. It was really interesting. You see, there are a lot of particularities out there that must be borne in mind if you're trying to go abroad. And in India, it happens to be the same. And regarding patents are particularly important and interesting. So, Hannah, could you tell us a little bit more about them?
Yeah, thank you, César. So good afternoon to everybody from India. India traditionally had a particularly good reputation when it comes to IPR. And I have pretty much good news for you with a new government, which have been in force past 2 years, and India moving towards $5 trillion economy in few years. There have been a lot of done in terms of policy level. So the Indian IP ecosystem has generally improved a lot. So whenever you are thinking about India, it's definitely a good time to go because the protection and enforcement has improved significantly. Having said that, there are a few very specific requirements in India which you might not find anywhere else in the world. So if you are thinking about patenting your innovation in India, I would say number one, please do check your patentability criteria. There are a few subject matters, so to say, which would not, for which you cannot sought patent protection. First one is, for example, software. So for software as per se, business method and algorithm are not patentable in India. The only reason how you can patent your software is if it's in connection with hardware, a computer implementing invention. That depends on the technical effect, the invention provided, etc. So software, obviously these days, every company which is in a technology, that would be something they might have to definitely think about and find out whether their invention would be still patentable. Other one, I think this is maybe not that many companies which would be in this particular field would be biodiversity related patents. So any applicant for invention which is based on research on information on biological resources obtained from India has to obtain permission from the National Biodiversity Authority. And again, that increases the process of grant and leads to the, it slows down the process quite significantly. And in terms of pre-filing requirement, the last one which I mentioned before I go, there's quite a few more, is a foreign filing permission. So presumably you are a company and you want to come to India, you set up your company here and you have a research and development, or you have Indian employees who are residents of India. If you want to file patent application outside of India, let's say PCT, or in the country where your mother company origin comes from, you have to apply for what they call foreigner filing permission. So after Indian Patent Office gives you the foreigner file permission, after that you can actually apply for your first application outside of India. So this is also very interesting concept, I would say. In terms of requirement pre-grant, India has a very specific requirement when you have to keep Indian Patent Office informed about your foreign filings. So meaning you have a patent application in your home country, your second family member would be India, and you file application elsewhere. So Indian Patent Office has to be informed about your foreign filing. During the examination report, the Patent Office would also highly likely ask you to give them your search and examination reports. This, they call it compliance with Section A. This compliance with Section A is absolutely necessary. And if you don't comply with it, A, you might not get the patent, and B, not compliance can also lead to revocation in case there is an infringement proceeding against you. And it has unfortunately happened many times, particularly for large companies which would have big, family long family members, they would forget or omit to submit their details, and that would be held against them during the infringement proceedings. And last and least are the post-grant requirement. So you would have thought, after I get a patent, I am done, I just have to pay the fees. That's unfortunately not the case in India. So India requires what we call a filing of working statements. That means that every year, once you're a patent holder, once you get your grant, the patent holder licensee has to file to Indian Patent Office that the invention is worked or not in India. It means how much you sell, how much you manufacture, etc., etc. There is a particular form, we call it Form 27 for this particular purpose. Yeah, I hope you hear me. Yeah.
We do. Oh, we lost her. It seems that today we're full of problems. What a proof. I'm trying to get her Hannah back in the meantime. Let me remind you that we are about to end this webinar. I might apologize again for all the IT problems that we're experiencing, and that after this, we're going to have the Q&A session that anything that hasn't been covered so far can be clarified directly by any of the experts, beside Matthias from the China Help Desk, because he's having some additional problems. So he can write it, so he can answer in written, but not using his voice. Now, Hannah, back to us. Anything else you'd like to add? These final remarks that you were saying?
Yes, yes, sorry about that. We do have internet fluctuation problem in here. So what I was saying, yes, it's required to file your working statement, which would have obviously additional obligation to you as a company. And last and least, India has a system of compulsory licensing. So there is always so-called a danger if your innovation is not used, or if your innovation is not given to a public for reasonable price, or the requirement of the public has not been satisfied, a third party can approach Indian Patent Office to issue obligatory license or compulsory license. I would like to, I mean, this is generally one of the market entry issues which we are addressing in India. Having said that, there has been only one case in case of Bayern for cancer drug, and the licensing under the fees which Indian Patent Office set for this particular licensee was quite reasonable. So although it might sound all I don't know, unfair or very bad, etc., etc. I think at the end of the day, even that requirement is there, there's still some sort of provision how you can kind of leverage it within certain means. So I think I can go about India and the different issues we might have here, or different exceptions which are here forever, but I think this is not scope of this webinar, so maybe we can address it in questions, answers, if you have any. And I pass forward back to César.
Thank you very much, Hannah. Yes, we could be speaking about IP and on any of the countries all day long, but we're not here to do that. So not today, maybe another day. And which there's all these particularities that we've been covering, and there are so many out there that we haven't been elaborating, but there are so many out there. So if you want to know more about them, I recommend to check our websites, because there are many of them, and you can check these fact sheet guides, infographics, and country guides that go more specific into this. And if you feel like something is not as specific as you would like to, you can always contact us, reach out through the helpline services, and we'll clarify that within 3 working days. Now, this takes us to the very last point, the very last advice, which would be the 10th one, and it is to verify the compliance of contracts providing the local legislation as applicable law. Um, why do I say this? First, because each country is absolutely unique, as we saw and we said so many times. And if we're trying to land this a little bit more specifically, is what I mean is that ownership for it first must observe local regulation, and secure ownership is really important here. If IP rights are the key to go abroad safely, they must be secure from the very basis. And if the ownership is not as clear as it is supposed to, you really have a problem. So do not take for granted that it is all yours because you paid for it or because you work a lot on it. There are by default regulation, which is very different in each country, that sets based on the scenarios who does belong to what. So there you have the work for hire, you may be an employee, you may be part of a joint venture, and if nothing has been said expressly during negotiations saying who would own what, you may have a problem afterwards. So you first got to see whether it could be agreed otherwise, and the regulation does not state that it has to go to a specific role and you cannot change that. Or if you can change that, and once done that, you have to put that in written, paper rules. And that's why, at least why lawyers usually say. Now, you also are advised to pay attention as to the applicable law, particularly in case of conflict. This is mostly the final clause in many of the agreements and contracts, and you gotta choose the right one. For instance, if you choose not the right one, it may end up in choosing a forum, a place where this is going to be solved, where there's a lack of knowledge or this lack of personnel who has some knowledge on this, and that would result in a backlog or in a bad decision or in unpredictability of what's going to happen. So you may have to take that very seriously. In fact, dispute resolution systems is really important in case of China because arbitration is very important there as they do not tend to recognize foreign decisions. Normally, local courts tend to be more very reluctant to do so, and they'd rather take a look on the case, decide themselves, and they give a decision, and that will be more easily enforceable. So if you choose the country where you want to do that, take that into account, depending on the country, where you want to go, who you want to appoint to decide a solution in case of problem. And also in case of Southeast Asia, there are a lot of new regulations that are being implemented lately. So if you're trying to go and do that rightly, please stay updated as to this. Otherwise, you may be very, very diligent in doing all the steps we suggested, but updated too. And this may be a real big problem. And with that, I would end, and this would be the last tip I'd give you for now. And as I said, there are so many out there that you may find useful that will be even more relevant to you. But from my perspective, you can say that the ones that I covered today and that my colleagues did with me are not relevant enough. So remember that we did a test before we started to measure the kind of level that you have on IP. Well, now it's another minute that I beg you to take to provide me uh, the answers to a new test so we can really see how much did you learn, how effective I was in letting you know these tips, and how much did you observe, and see whether you came from a newcomer level to advanced one in just 30 minutes, which would be more than okay. Now you got the test on the chat section. Please go ahead and do it. As again, it is 1 minute. Go ahead and let me know how many of you have learned so much that we can really say that this service is as effective as it is expected to be. Otherwise, of course, we're going to provide you with some feedback questionnaires so you can let us know your opinion on this, what can improve, what can be improved in order to provide the best service at all. Now, 1 minute, which started 30 seconds ago. And in the meantime, and as we are about to start the Q&A session, you can write all your questions on the questions tab so you can really develop them and see whether someone else is taking them or whether it's something that no one covered can be addressed right now. We're absolutely at your disposal. And remember, it can be answered in written, like Mathias would do, or we can do that by voice as the rest of us are available for this. Okay, now 10 seconds to go. I see that some of you have provided the responses. Thank you very much for this. It seems that you are very active. Good, good, good. The rate isn't as high as expected, but please do a final effort and let us know whether you learned that, or whether you have been one of the IP experts just because you attended one of our trainings. This is a nice question because Lizelle asked if we're going to get the correct answers after this. If you want to know them, yes, but now I cannot provide them so far. But yes, if you want to give you the answers, we're having a problem in doing so within the Q&A session. Now this minute is over. I see that many of you provided these answers of the test. Thank you very much for your feedback. You can still do that after this test, but now I guess it's time for the questions. So now, please let us know what you would like us to answer, or if not, I'll take for granted that everything was as clear as I have desired. before we started. Now, no questions. Remember, you have to write it on the questions tab. And in the meantime, and as I see that some of you are still responding, I'm going to encourage you to use our helpline service in case you want to know more. And let me remind you that you are receiving this recording right after this webinar. So when I click the end session button, you're going to have it on your inbox. And of course, we are at your disposal 24/7 via email. Now, as this minute is over, yes, I can give you the right answers. And they're pretty simple because from what I think, all of them were addressed during the sessions, but we're gonna go one by one. Now, first question will be like, okay, design survey, check them. Differentities with no local domiciles need to appoint a legal representative in the destination countries to register their IP rights. The answer to this was no. It is false because if you don't have any local domicile in any of these countries, you won't be able to make any registration. In fact, if you have a domicile, in case of China, it would be even not enough. You need to have an appointed local representative, preferably an IP lawyer, in order to be able to register your IP rights. So if you had the wrong, I'm very sorry. The second one was registered copyright protected works are needed for a certain legal action. And yes, the answer is true because once registered, you have a proof of authorship. And in many countries, they would ask you for this kind of evidence for enforce your rights, for instance, in case of you want to receive some money as a compensation. This is really needed. Now, the third one, if I registered my IP rights only in Europe, I can safely operate abroad. The answer would be no. Of course, you have to take care of your first filing. It is more than needed, but intellectual property rights are territorial, meaning that if you don't register locally in the destination countries, you have no monopoly, no right. So you can enforce nothing and you can be copied, and anything you are doing over there can be either a copy of someone else's who has properly registered there or be absolutely exposed so anyone else could use it and you can not go and request him to pay you any fees because there is no exclusivity based on a registered IP right. Now, the fourth one, the publicly available databases contain all the relevant information. The answer will be false because we'd love to do so to it to be so, but many countries do not submit the information to these databases, and hence they are not as comprehensive as they should. For instance, Myanmar has no online database at all. So not all the information is there. The good news about this is that professionals do have access to complementary IP databases and can give you the bigger picture about what is available and what not. And as to the fifth one, a solid Europe registered IP right can benefit from priority rights thanks to the PCT or the Paris Conventions were available. The answer was yes, absolutely yes. The PCT, the Patent Cooperation Treaty, does really provide this 30 to 31 month period. Once you registered first, within all this period mentioned, no one else could claim that his applied pattern should go first. You keep the novelty, and it is like if you did that before he did, no matter if it wasn't the third month. So yes, it is so good that if you do things right locally in Europe, you may export that very good using these international agreements. And the final one, the foreign court decisions are always accepted in the destination countries. As we mentioned, we hope they were, but they are reluctant in some cases, as the example of China. It isn't supposed to be all the same, but it may happen, so bear that in mind. And the answer would be false. And now, with that all, I see that we have no questions. So the only thing I can do right now is letting you know that there is some, there you go, there feedback questionnaire that I'd like you to take just 1 single minute to complete. More questions will come up with the live cases. Okay, thank you very much, Andre, for your opinion. And now, just please us and the link provided in the chat right now. Let us know what you think about this webinar, about the contents, about this humble speaker that was with you, and about the top ones that were with me during this session. And you can go and check this link, please, and let us know what you think about it. Please don't leave before completing it. It is very useful. Now with this, you can anonymously let us know what was good, what was bad, what should be improved, what would you like us to cover, new topics, etc. And there are only just 7 questions. It is so easily to be completed. And in the meantime, I'm going to give you a short message. Of course, I like to thank all my colleagues for being here today, for the inputs, for the contributions, and for overcoming all the technical issues that we experienced. Now, the sooner I mention, the sooner it happens. Hana fell down again. This is what happens. There are not only IP problems out there, there are also IT problems based on location. And India tends to be some place that may happen to be problematic at least. Okay. Now, but again, thank you very much
Uh,
for being there. Thank you very much for being there. I said.
And thank you for the invitation, César.
Now, let me remind you that if you have any other query or suggestion, or you simply want to have further information about this topic, the International IP SME Helpdesk at your entire disposal. Our helpline will provide you with a solution to all your intellectual property related needs within 3 working days. And as all our services, this first line assistance platform is totally free. And of course, your data will be treated in strict confidence. Okay. Now, you may either contact by phone, by web form, or by email. Remember that no question is too little to us. For further information, go visit our web portal and stay updated to the latest news and events thanks to our newsletter. We also encourage you to follow us in Facebook, Twitter, LinkedIn, and YouTube. On behalf of the International IP SME Helpdesk, thank you all again. We hope you enjoyed the webinar and hope you see you in the next ones. Goodbye.
Thank you. Bye.
Bye-bye.